Livestream Insiders is a weekly live show where we explore the best practice case studies in live video, social video, and live streaming. In this episode from the 22nd of May 2016, we're in conversation with Adam Rendell, an IP and copyright lawyer from Taylor Wessing, exploring the IP and copyright issues of live streaming.
Absolutely. Okay, let's move on to our guest. So I'm expecting Adam to pop in and to ask to join our conversation. And let me give you a quick introduction, then hand over to Krishna, because you know what, I've been around the country here in the UK and other places around the world, talking to people about various aspects of presentation and production, whether it be on TV or radio. But very often it comes up about legal implications, and I'm really interested in what you can and can't do, partly because I work for this fantastically huge broadcasting organisation, so I've got to be really on top of what it is I can say and can't say, both legally and also perhaps ethically as well. And we're really interested and really pleased to have Adam along. So Krishna, over to you.
Yeah, so in terms of our show here at Livestream Insiders, we've talked about the issues of copyright, of intellectual property on the way through. So we thought it was really important for us to have somebody from our, let's say, our geographic area, so in terms of Europe. So a disclaimer at the beginning is that we are not going to be talking about specific legislation, even related to Ireland or in terms of in the US. But I know that, Adam, you're so equipped in terms of being able to talk about the issues of intellectual property and also media copyright issues, because that's your area of specialism, that actually you're going to be able to give us some principles. So if you are watching this in terms of from a different country, then certainly make sure that you look at what's relevant in those other parts of the world in terms of where you're operating, where you're broadcasting in. And today's show is really about the implications of copyright, intellectual property, and those kind of issues if you're doing live video and live streaming. Though I know it will come a little broader in terms of social media, because, Adam, I know that you are a speaker at a lot of conferences and you get asked for advice from organizations, big and small, including broadcasters. So tell us a little bit about us, perhaps, in terms of your role and what you're doing in the organization you're in.
Thanks so much, Krishna. Hi everyone. Hope you can hear me. Very good. So I'm at a law firm called Taylor Wessing in London. I specialise in copyright and media law, as Krishna says. The people I advise on these kinds of issues, some issues as you get in the offline world, so advising broadcasters or advertisers or publishers whenever they want to use other people's content. But equally, the example you gave before, Krishna, of the blogger who received a grumpy letter from a rights holder. I will write those kinds of letters every now and again to enforce our clients' rights. So I've got to look at these things from both sides of the fence, from you're using my stuff, are you able to, but also I want to use your stuff, and how might I be able to do so.
So you've obviously seen all sorts of blabs and perhaps Facebook Lives and Periscope streams, Adam. So what is it that jumps out at you kind of immediately that makes you go, makes you shake your head and also perhaps rub your hands with the possibility of writing one of those letters?
Well, you say rub your hands. It's always a shame when you have to go and enforce rights. You know, you'd rather people behaved in the first place, but there we are. It was funny when Krishna was talking about Facebook Live before. I flicked over to the map, and just when you sort of scroll over the blue buttons, I saw someone live streaming basketball coverage for a live broadcast of a basketball match. There was a karaoke performance in a pub, and there was a gig that seemed to be live streamed. Each of those three examples, you've got people recording copyright material. In the basketball case, it's the broadcast itself, owned by probably the basketball league of the match. The karaoke, you've obviously got the music, and you've got the performance, Likewise at the gig. At the gig, you might also have some recorded music as well as just the music and the performance. So in each case, you've got to think, well, can the person who's broadcasting it use that material? The examples you gave before, Peter, of reading a novel, being in an art gallery, absolutely the right examples here to pull out the issues of, well, you're using other people's stuff. To give it an example of something that doesn't make me scratch my head and wonder what's going on, there was a Sky News journalist broadcasting from the launch of, is it world's biggest cruise ship being launched today in the UK. Much more relaxed about copyright when I see a video like that, because there's sort of nothing to worry about. There's no sort of copyright material engaged there. I mean, there might be other issues about privacy and taste and standards and decency and that kind of stuff, but from a copyright perspective, much more relaxed.
And you know what? I often think that the thought process has to be, what I'm streaming this, say, concert or bit of music, to get more listeners, to get more viewers for me. You know, that's the conscious decision that someone is making, because they obviously want more people to be following them and to be consuming the content. So if you're doing that, then it kind of makes sense that actually the person that created that stuff in the first place is deserving of some of the following, some of the views, or some of the money that you're going to be getting off their back. That's essentially the point, isn't it?
Absolutely right. I look at it, it's sort of a rule of thumb that I think about is, why are people tuning into this? Are they tuning in to listen to the novel, or look at the pictures in the art gallery, or watch the basketball match? If the answer to that is yes, and if that is the primary purpose of why it's there, why I'm doing this, why people might watch it, you're probably creating content. Right, the rights owner there should be able to at least control what's going on. So in the basketball situation, the dynamic that the leagues want to control the exclusivity that they give partners. So if you want to watch what's going on in that basketball match, then you should be doing it via the official channels, who have paid, frankly, tons of money to have the right to be able to broadcast that. You shouldn't be able to sort of hijack that value. And that's where copyright comes in. Likewise, the art gallery. You know, the art gallery would rather, I suppose, you go and visit them rather than watch it on the live stream. But just to flip that, and I've seen on the live chat feed mention of fair use already. You know, the two words that you automatically, as soon as you hear the word copyright, you automatically hear the words fair use, right? The sort of natural bedfellows, two sides of the same coin. You think, well, are the ways I can use the novel or the pictures in the art gallery? And there absolutely are. Those ways are slightly different between jurisdictions. You know, in the UK, we don't have a general fair use principle like they do in the States. We've got sort of narrow examples that you have to fall within. But it would be perfectly possible for someone to read a novel in the circumstances of the live stream, but do so relying on the fair use, or in the UK, the fair dealing provisions. But then the question there would be, well, are they tuning in to listen to me and my views on the novel? So you might be critiquing the novel. You might be discussing its literary merits, or its place in society, or just reviewing it for the sake of reviewing it. If that's what you're there for, if you're wrapping up your use of this copyright material in the context of your own creativity, your own content, your own input and discussion, then you may well have a fair use defence. But the point there, to use your idea, Peter, is that you're not tuning in for the novel, you're tuning in for what the person's going to say about the novel.
So let's give if I gave you another example briefly, I'll hand over to Krishna because I know she's got lots of questions of her own. But if I wanted to do some karaoke, or with perhaps a guitar, and I don't know, it's Robbie Williams and Angels, for example. For me, just to sing that would be copyright infringement. However, if I was showing people actually how to play that on the guitar, and actually going through the different hand movements and so on, that would be different, because then I'd be including some of my own kind of intellectual copyright and my own interpretation and teaching people how to produce that kind of sound. Yeah.
You've got a better. I'm glad you chose Robbie Williams, one of my favourite artists. So you must have. I don't know how you knew that, but coincidence. You're right. That gives you a start of an argument. I'm not convinced though that in that specific example you would get away with it, because you still may well be using the whole track there. If you're sort of pulling apart maybe his chord progressions, or how Guy Chambers was inspired but to write the song, or maybe there was that story about whether there was copyright infringement in the lyrics of Angels. You've got a better argument there. But I completely agree on the sort of the karaoke side of things. If no one would tune in to listen to me sing Robbie Williams' Angels, but yeah, absolutely right. That's a no go unless you've got permission from the publisher.
Before we even get to being live on air, we do things such as promoting the live stream. So Adam, for this show, I actually created my own video in terms of promoting you. I used an image within that video, which I knew that I had availability to use, and it was one that was available in terms of for use by anybody, or I take a photograph. I'm interested in terms of what you see in terms of extending that reach of just being live on air, which I'm sure we'll come back to, is actually what about when we're looking to promote or even tell people about a replay. So people are using images, they're using video content, they're using animated GIFs. Animated GIFs now are available directly within Twitter. Animated GIFs are now available on Android in the US from Google, in terms of actually if you have a look at on the Android app, you can actually look at things there. Tell us about what we need to be considering. I mean, even to the extent of, I know you've got an avatar on Twitter. Could I just take your image, and knowing you're coming on the show, but I haven't agreed with you to use that, can I just use your image now to promote that you're coming on the show as a guest?
Just take that example of the avatar on Twitter. If you're using that on Twitter itself, and promoting this show on Twitter and just using the images within the same ecosystem, then because of the licenses I've granted when using that image, when uploading that image to Twitter, it's wrapped up in the terms and conditions of your use of Twitter. So the license you grant to Twitter captures the sort of on-platform use of that image. But if you had gone to my Facebook page, for example, or my firm's website, or my LinkedIn, and taken that image and then put that either in your video or in your just put it in a tweet, then you don't have the permission to use it, you're running a copyright infringement risk there. I would say that when you're using the images in the context of promoting something, you're creating a slightly higher risk for yourself as a matter of sort of practice, and the legal risk is probably the same. But in terms of you using that image to generate traffic, it's why I suppose one of the reasons why when sort of brands or whatever are using copyright material in advertising, you're always a bit more careful, maybe a bit more conservative on the views that you take, compared to when you're using it in the editorial content, because there's from a sort of almost fairness perspective, your sort of the free riding you might be doing there on that creativity to draw people in is a bit more, potentially a bit more of a problem.
So what about things that we're seeing, such as animated GIFs being created and used? I mean, for example, there was one which wasn't promoting specifically a live stream, but they were promoting themselves. I don't know if anybody saw this, but there was a very clever video put together, one would argue, which was being put together by somebody who was looking for a job with BuzzFeed, and they took clips from Obama speaking, they actually edited it in a way as if they were kind of giving an endorsement of this person. So of course he was trying to do something that would get BuzzFeed's attention. It was quite cleverly edited. He's obviously spent a lot of time to be able to source specific phrases and put them together in something. GIFs are almost the same as that. In that case, the one example I gave you there happened to be a video I saw on YouTube. Equally, you could have just taken images and actually put them together again to promote himself. He was, in that case, promoting himself as a live stream, but the same principles apply. Would he have the right to take bits of content in that way and stitch them together? I mean, equally, could I take, if I could find lots of videos of you, Adam, speaking at conferences, could I have taken those images and, if it's not on Twitter, let's say I found them on YouTube, could I take slices of that and put them together to be a show reel to say, come and hear Adam speak today on this session here on Livestream Insiders?
What hasn't been decided in the UK yet and across Europe is whether the size of the extract you take to create a GIF or that BuzzFeed applicant took is a sufficiently big part of the copyright work, the film in this case, to be an infringement. There is certainly a pretty good argument that it is big enough. And in the clip you mentioned, Krishna, there were bits where Obama was talking for a bit longer. And other examples were just a word or two. And it is sometimes an issue of the length of extract you take. So the longer you take, the more risk you're running. But I could not say that even the sort of second or two clip people take typically to create a GIF, for example, isn't going to be copyright infringement, particularly in circumstances with GIFs where you're taking something that's pretty important to the source material, be it a film or a TV show or whatever. You may well be taking something that's pretty important in the context of that show, and when you're doing that, you're again raising your risk of infringement. And there have certainly been instances of people enforcing rights against GIF, against using GIFs. I think the NFL last October got a couple of accounts taken down who were using lots and lots of GIFs from footage of their matches. So there's certainly appetite to enforce. There's been a recent case in England with 8-second clips of cricket broadcast coverage were sufficiently long to infringe copyright, and none of the defences we were discussing before applied. So I would always exercise caution in the use of GIFs. You might be able to rely on a defence. Probably a parody defence seems the most likely to apply, which is defence we've got in the UK now, and it's been in the States for a long time, for example. So to go back to the BuzzFeed example, if what he's taken there is enough to infringe copyright without an exception applying, I think there is a risk, because I'm not convinced that any exception, at least in the UK, would apply. I think in the US, because you don't need to say you're doing it for a particular purpose, parody or criticism or review or whatever it may be, I think he's got a better chance of relying on fair use in the States than he does of relying on a UK exception. But I think he was a UK-based video journalist applying for BuzzFeed UK. So I know we'll talk about sort of which laws you review later on, but it strikes me that he would have to work pretty hard to say why it's not infringing there. But I think he'd still have an argument. This is a great example of an area that isn't yet decided, and people are there to push things a bit. It wouldn't be a surprise to hear that the High Court in London has not had a GIF come before them, or the kind of YouTube 90-second clip we're talking about from BuzzFeed. So there is still a lot to be played for, and I think what the view that broadcasters and creators of this concept have to bear in mind is, what level of risk am I willing to take? how can I mitigate that risk? What can I do to reduce it and improve my case? But it's got to be done in the knowledge that there is a risk. I'm not able to give a clean bill of health to anything, partly because the law hasn't yet decided which side of the line these kind of videos fall. So as I say, it's a level of the question of the risk you're willing to take.
And that's one of the big questions, isn't it? I mean, as we've seen, we won't talk more about this case, and I'm going to be certain, Adam, not to. But there was a case in the courts this very week where the judges were accused of not understanding the whole issue about internet and people's privacy and what kind of information was available from one side of a country's border to another. So what I'm saying is that the law and those interpreting the law have got an awful lot of catching up to do, haven't they? I mean, this is still a developing area, but it's moving much faster than the actual parliaments and rulemakers can actually cope with.
Well, in this instance, I don't think no legislature in the world is ever going to produce a sort of gift law. The reason that things haven't it's not a question that it hasn't caught up. It's just that the opportunity for a judge to make a decision hasn't come up yet. That's where we're lagging behind. And, you know, as a practicing lawyer, you know, you'd love the opportunity to run those cases and take those cases to the court. And it requires a test case, as always. And I suppose my role is partly to make sure the people I advise is not to be the test case. It's to make sure you do things in a way that is reducing the risk sufficiently to make it a difficult case for someone to engage in potentially expensive and long-running mitigation.
Now, Krishna and I were at a conference about 2 or 3 weeks ago, and the number of people who were holding up their phones on the front row and were either recording or they were live streaming the sessions as they went on. I mean, Krishna was one of the moderators of these sessions, so probably looking down from the stage, she saw all sorts of mobile phones pointing in her direction, and a lot of people's content. In fact, one person did point out, had I known, he said, that my whole presentation of 10-15 minutes was being actually live streamed to the world, he said, I probably wouldn't have given permission for that to have happened. I mean, this is a new thing. If someone can actually put up with, you know, wobbly phones and bad audio and just as bad lighting, that is a problem, isn't it? Because that is someone's speech or presentation that they spent days putting together. It's from their own experience. It's some of the material and examples that they have put together in a certain way. And to actually have that beamed around the world for free, that's going to get a lot of backs up, isn't it?
I think that's absolutely right. The first thing I think of in that situation is the conference organizer, who is charging, I suppose, I don't know how much it costs to go there, but you know, probably a few €100 to get your delegate pass. Why bother? I mean, obviously you're going to go to a network, but why not just sit at home and watch the live stream from someone on the front row? So then it comes not necessarily to the speaker, but it comes to the conference organizer to go and, you know, tap you on the shoulder and say, you know, like happens in cinemas. You know, no recording equipment should be used while people are on stage. And from the speaker's perspective, they have intellectual property rights in their sort of performance, if we can call it that, but also their script and their slides, for example. You know, their slide might contain copyright imagery, for example, that while an exception or a grant of permission covered their use in the conference centre, doesn't cover their simultaneous streaming use or doesn't cover use in a recording. And I suppose from a sort of content basis, I imagine it wasn't a sort of Chatham House situation at this particular conference, but you can imagine yourself being in a situation where you're in a sort of circle of trust, almost, these kind of conferences, where you know what you say in that room will be understood in a certain way, but taken out of context might mean something entirely different. So, you know, for all three reasons there, you can absolutely see why some control needs to be exercise. And ultimately, it comes down to the conference organizer either saying to their delegates, don't do anything, or saying to their presenters, but by the way, this is going to end up on the internet. Bear that in mind.
Yeah, absolutely. And presumably then in a bit of negotiation that the presenter may say, well, in which case that's another couple of €100 or dollars for my fee. It's going to be widely distributed.
Exactly. I'm flying business, not economy.
We're getting some great comments about your content, Adam. So I just wanted to acknowledge the fact that lots of people are here and they're saying that it's really powerful and really helpful in terms of what you're sharing. So thank you everybody for being here. And I know that some people are also commenting about they've had some problems. We can just pause for a minute, I'd like to go to some questions that are coming up in terms of in the conversation. So one of the things is for example, we talked about I could have taken an image. If you want to know more about this, go back and watch the replay of it. But Adam was explaining about if I'd taken an image of him, which I didn't, from Twitter versus if I took it from his website or Facebook, there's some different implications there. If I was using that image to promote the fact he's with us on this show. And in fact, therefore, the question would be, Adam, how would you, in that case, you would have known about it because I'd have mentioned it to you. But in practical ways, how are people able to discover, or what are the things that people are doing to discover that says that people are using their images, and then that probably drives them to come and talk to an organization and a lawyer like yourself to say this is not being used appropriately. In that case, I would have tagged you, so it would have been easy for you to have seen I'd used an image, and you probably wouldn't have had a problem unless it was an image that you didn't like. How are people actually going about it? And particularly in terms of lots of people here are not broadcasters. They're not working for TV stations. So they're probably new to this kind of topic.
Well, if we carry on the example of the use of a picture, if you're using the images from people like Getty or Corbis or Shutterstock, those very sophisticated photo libraries, they've got very sophisticated technology that's able to find out where their stuff is being used online. And so those tools will identify any infringing uses, and that will generate an invoice or a cease and desist letter. I think people find out via one or two portals, maybe. It becomes very big in one platform, and then suddenly you see it scraped and has proliferated everywhere. And then you're looking at a manual process. But it's very, very difficult to properly police where your content is ending up. We advise very sophisticated, substantial rights holder organizations who struggle with this. So there is no generally applicable easy solution which is going to help you find out where content has ended up, unfortunately.
Yeah, I've had a couple of situations where, not necessarily related to live streaming, it was talking about live streaming, it wasn't the live stream itself, where actually my image has been used by a large organization and also by a news organization. And in one case, I only got to know about it by accident because of the topic I was following on Google Alerts, which took me to their blog, which then took me to the content. And in the other case, somebody alerted me because my name was on the image and they told me that this news organization had used it. Peter, you might have, because we follow some of the same content, you might have seen the unfortunate thing with a broadcaster, I think they're in the UK, whose image had been taken and was actually used on Flickr, and that Flickr image was able to be used, and it was used to illustrate a not very nice story. And they did put underneath it, here's a disclaimer, we don't believe at this time that this person has done it, this is another journalist. But that journalist can't have been very happy with the negative story that his image was actually featured at the top of in the article. So it is quite challenging to be able to actually track that.
Absolutely. So and I suppose that there are all sorts of kind of grey areas and other things which are happening on there. So we've talked about we've talked about music, we've talked about intellectual property, we've talked about people's pictures as well. Where else, Adam, have you spotted that people are coming a little bit unstuck? Well, in fact, it's something that I mentioned a bit earlier on. I'm going to answer my own question now, so sorry about that. But and this is one of my favourite ones. In fact, I've got this example right beside me because I was talking about this quite often. And then it actually appeared in this article in the Observer back in February. And that is, I don't know whether you recognise this particular location, Adam, but it's just outside City Hall in London. And of course, a lot of people do periscopes from there or various live streams because it's quite an iconic viewpoint from there of London Bridge in one direction and down the Thames in the other direction. And of course, the beautifully shaped City Hall as well. And yet actually taking photographs from that point is actually illegal. Is that right? Because this stretch of land here is actually private land, isn't it?
It's I hadn't appreciated it was private land. I mean, there's I suppose two issues we have to think about. There's the potential copyright in a work of architecture, which City Hall is. Now that debate has got quite political at the moment because there's a thing called a freedom of panorama. I don't know if you've come across that, with people taking pictures of city landscapes and obviously capturing sort of iconic buildings. Now in the UK,
the landscape, it would presumably belong to the city for its own publicity and marketing.
Well, it would be the individual architects of the buildings which make up that city. But in the UK, as I was saying, we got an exception which allows people to take pictures or videos of buildings like City Hall. So the copyright perspective isn't as important here as the sort of trespass.
Yeah.
Which is you grant someone permission to come onto your land. You see this come up in live streaming of football matches, for example, from this stadium. A couple of years ago, the Football Premier League in England had a big crampdown on use of Vine for key moments in matches. And I think Manchester United banned people from taking in iPads to Old Trafford because of the risk of the match being live streamed. And that isn't relying on copyright. That's relying on the grant of permission you provide to your spectators when they come into the stadium, or in the example you were giving, Peter, sort of walk onto that stretch of the South Bank to say you can come onto my property, and would apply equally in the conference example we're talking about. You can come into my conference hall, but you've got to play by my rules. And one of those rules would be you can't live stream or take pictures of or whatever what's going on in this bit of property. So not an intellectual property thing at all. It's actually real property, as in land and, as I say, trespass. So those in control of that land are able to set the conditions of entry, and those conditions, I think we're coming to the view that you might be situations where you'd want to impose conditions that say do not live stream, and for whatever reason that stretch of the Thames must be one of them.
Yeah. I mean, after all, if you were filming a Hollywood film in London, then you would have to pay big bucks, wouldn't you, to have access to those streets or to show some of those particular landmarks and so on. And live streaming is broadcasting, although on a much, much smaller scale.
Yeah, exactly.
I've come across that certainly in Dublin, where there's certain areas in the finance centre, financial services centre, where you couldn't take photographs. But I'll give you another one, which was I was at an event in Google, where it was about a year ago or so now, and this was in Google in Dublin. And when we were in a room, we were told that actually content was going to be filmed and recorded, so we didn't want to be in it sit in a certain place, but we were also told what we were not allowed to do ourselves. But interestingly, when I went outside, so I did do a live stream from within the Google offices in an area where I knew that I could do that, and actually did that on Periscope. But then, in fact, when I went outside the building and onto the pavement, I actually was capturing some content, and I was told by the security guards, you can't take it. So I don't know whether or not that issue of trespass, do they own part of the pavement? I don't know. But yeah, you have to watch out in terms of where you are. And if you're an event organizer, be very clear with people, I think, is the key thing there. I know there's lots of people who are here today who are also producing content on behalf of the other organizations. And so one of the things I wanted to ask you about, Adam, is about a situation. It would be small fry in the scheme of things for many people, wouldn't probably even register for them. But there's a race that goes on, a cycling race that goes on in the UK, and it's called the Tour de Yorkshire. So it's based off the Tour de France. It's actually been great for the county of Yorkshire to get some interesting publicity around it. And that event was being live streamed. And that live stream was actually, all organised and to be broadcast through a particular broadcaster, a commercial broadcaster in the UK. And obviously that was important for that county, also partly for tourism, but it's also important for the context of the sport. And I picked it up as a story because, in fact, my husband told me about it because of the fact that this was the biggest race, I think, ever, or biggest prize ever in the UK for women's cycling. And the live stream had failed. And the issue with the live stream was actually you can imagine that you're following a cycling race. It's an aircraft that's up in the air. And there was a problem there. And the nearest aircraft they could get to replace it was actually in France. Now, most of us are not going to get involved in that kind of complexity of live streaming. But it got me to thinking about those of us who are starting to think about producing content on behalf of other organizations. What do we need to start to take into consideration in contracts? Because, I don't want to get into necessarily where the liability lies for that live stream failing. Clearly, the people who were watching that cycling or were hoping to watch that cycling were disappointed. The people who were participating in it were probably disappointed that it couldn't be live streamed for some time. What should we be thinking about, though, Adam?
So as I said before, it's a question of identifying the risk and then allocating the risk between the various players in sort of the creation chain here. So it might be that the event organizer has said to its sponsors, I guarantee you X number of eyeballs and you will be paying me for X number of eyeballs, and if I get extra eyeballs, then you pay me some more money. So the organizer, its financial success is dependent on a guaranteed outcome. That guaranteed outcome being a live stream of the race. So because they have guaranteed someone an outcome, they need to be able to get assurances in their contracts. And the contracts are the key thing here. They need to get assurances in their contracts from the airplane provider, the producer, the people who are filming, that outcome will be achieved. And then the interesting negotiation point when you're trying to put those contracts in place is, well, what happens if that outcome isn't achieved? Am I on the hook for the cash that you have lost because that outcome wasn't achieved? Do I have to pay for it? Should my liability be limited to a certain level relative to how much I can control? Should there be exclusions of liability in what we call force majeure circumstances? So if the plane was struck by lightning and that's why it fell out of the air, say, then maybe that wouldn't be something the producer would be responsible for. Contrast that with the plane just broke. The tire exploded or something. Now that might be something that they wouldn't allow within a force majeure situation, and if that happened, then they would be responsible, and they would be responsible for sort of making up the loss that their default has caused. So it's a question of negotiating an allocation of responsibility between the people who are providing the various inputs.
So you're watching a live stream, Insiders, and Adam Rendell is our guest. So let's wind things up. So if you've got any more final questions, then just pop those in the chat. So we'll give Adam an opportunity to say if you want to contact him in a few moments' time. First of all, I mean, let's finish off with a bit more of an overview, Adam, because if rules and if laws are different from one country to another, where can someone actually use their solicitor to get things sorted out? I mean, if fair use isn't appropriate, if fair use it doesn't exist in the UK and I'm streaming from the UK, but obviously around the world, am I in trouble because this is where I'm doing the streaming? Or if I go to the US and use fair use policy, does it change because I'm a Brit but I'm in the United States? And under what circumstances do I use what laws depending on where I am? Do you see what I'm trying to say?
No, that's a really, really crucial point, because as you say, the laws are different everywhere and your audience is potentially everywhere. Without going into the various technicalities of choice of law and jurisdiction and all these kind of things, the sort of rules of thumb that I talk about are: think about where you're based, where you're broadcasting from, because A, is a matter of law, and B, is a matter of practicality. You're quite likely to be sued there. So here I am in London, and Peter, by your background, it looks like you're in London as well. Krishna in Dublin. UK law, Irish law, an obvious place to start. We then have to look at, where is the audience based? Where are you targeting your viewers? Where do you believe the majority or a good portion of your viewers to be based? Now, in this instance, looking at the live chat, it looks like there's a lot of people in the States. So thinking about fair use principles makes perfect sense. And speaking to a US lawyer would make perfect sense, because there is value in the US copyright that a copyright owner might want to enforce, because that's where a lot of eyeballs are. So that's the second consideration. The third consideration is to think about where a possible claim might come from. So if we're in that art gallery example, if it was an art gallery showing paintings from a French artist, even though you're in London, your audience is in London and in the US, no one in France watching it, the French artist or his or her estate might sue in France, because it's easier for that litigation to happen there, because it's on their doorstep, it's by their rules. So it might be worth thinking about the copyright position in France as well. Now, so we've established 3 or 4 countries there, and this is a relatively self-contained example, deliberately so, to make it easier for present purposes. But no one wants to spend the time and money to go around the world. So you have to fall back on a risk analysis. And those 3 principles I've just been discussing seem to me to be the 3 very good starting points to bear in mind.
So I could be in a London gallery broadcasting to America, but infringing the rights of somebody in France, and that could involve potentially 2 or 3 sets of different protocols, different laws, different jurisdictions, different sets of legal teams, and so on. Boy, oh boy.
Exactly.
Yeah, that's this frightening stuff, isn't it? Really.
Well, it potentially, but you can do things about it.
Yeah,
that's why people like me come in, right?
Yeah. So
people like you come in to sort of educate people.
I would presume
worried about.
Thank you. I would presume that the best thing is take advice first. Don't think that you can get away with it, and then try and knock on your door afterwards. But it's best to come to people like you and seek advice. This is what I'm planning to do. This is what I've been asked to do. This is what I plan to show or say. We haven't even got into defamation and what people are actually saying, and that's another huge area potentially. And unboxings and critiques and so on, because obviously you can't just say absolutely anything. But it's best to come to you before rather than afterwards, yeah?
I think that's very much the case. It's going to be cheaper, it's going to be low on legal fees, and hopefully you can avoid having to pay any damages at all. And the example Krishna gave of that blogger and the pictures at the outset. If you as a blogger or a publisher, you go on to a Getty website, for example, and you buy your editorial permission for whatever their rate card fee is, that seems to me a much more straightforward way of dealing with it than having to deal with it a month later when you get one of the nasty cease and desist letters with an invoice attached.
And here's a final thought for you in terms of actually even the promotion of the content that we were talking about before in the video content that I used. I actually used a particular app, but one of the things I did do is I checked with the app provider in terms of what are the rights for me to use the music, because in that video that I created to promote you, they've got images, which is I used one image and I used an icon, and they also have music. And so again, you just need to be clear if you're going to use content that you're creating even on a mobile device and you're using an app, that they may have said you can use this for non-commercial use. I was using it for, we could argue it's non-commercial use in terms of nobody's being paid for this, but get into another discussion about if this had been a paid event in terms of actually using it in that way. So just be careful, even when you're creating tools with creating content with third-party tools, in terms of what the rights are. Brilliant tips you've given. I think a lot of people have really appreciated the things that you've shared today. Adam, do you want to tell us how best that people can get in contact with you, particularly if you're in Europe, which is obviously where you're based in London?
Sure. So you've got my Twitter handle on the screen there, AdramIP, or my email address is a.rendell@taylorwessing.com. If you Google me, I'm normally the first thing that appears on your search results. My website, the firm's website has got my profile and contact details on as well. So more than happy to talk about this in more detail. It's a lot of fun, and as we were discussing, lots of ways to trip yourself up if you don't get the advice in advance, as you were saying, Peter.